working in a top secret location right outside the Van Zandt County Courthouse. You know, one of the things that came up in the practice today, and it's not something unusual, it's something I've touched on before, but it is the requirement that you absolutely be punctual and show extreme candor to the court regarding the seriousness of whatever proceeding you're there for. Everybody gets stuck in traffic, things happen, there's wrecks on the interstates, but failing to plan and failing to appear on time can result, especially if it's an appearance in a felony case. Judges are usually taking things a lot more seriously if it's a failure to appear in a felony case, and the reason why is because they figure you're familiar with the system. Now, whether that be true or not, in some courts, in some counties, not being punctual results in an automatic charge, revocation of your bond if you're out on bond, and another charge for failure to appear. Don't be late. If you're 15 minutes early, you're probably late. That's the mindset you gotta have. You've got to be punctual, because showing the court, showing the prosecutor that you are taking this with the absolute most sincerity and most seriousness that it requires, because let's face it, your liberty's at stake. You're under a charge from the government of the state of Texas. Your liberty is at risk. You can be jailed, or other penalties can be imposed, fines, probation, but your liberty is going to be restrained, and you're going to get your due process. But if you're late and you're the cause of the delay in your due process, that due process may not go the way you want it to. Those requests for leniency may fall on deaf ears if you are not in court to defend yourself, to represent, to be there with your attorney, whether that's a court-appointed attorney or not. There's a few other tips if you're ever in one of these scenarios. One, besides being on time, dress and speech matter. Speak respectfully and with courtesy, dress conservatively, and use your manners. You know, Miss Manners says when you're at the criminal courthouse under felony indictment, use your manners. Be courteous, be respectful, treat others with dignity, you'll be treated with dignity. Treat others disrespectfully, not going to go so well. So these are things to a big debate, and it's a case-by-case debate. But it's whether transparency will help you in this scenario or not. In my experience, transparency, can be more beneficial than not. The criminal defendant has absolutely no obligation to give the government or the state of Texas discovery unless the criminal defendant is under subpoena. So I want to touch on a little bit about what how the state of Texas conducts its investigations, how the United States government conducts its investigations. They conduct those investigations through the subpoena power of the state prosecutor or U.S. Attorney's Office through the grand jury, and otherwise investigate the case, which may result in the indictment of many or one defendants. And that's how that process works. Defendants don't have the right to present evidence at the grand jury, but sometimes they can, and they're not defendants yet, they're just targets of an investigation. Sometimes the state of Texas will permit that, but it's a case-by-case scenario, and they won't always do that. The subpoena power of the grand jury is extremely broad and extremely powerful. It's sweeping, in fact. There's not much that they can't demand you turn over. If you're ever in one of these scenarios, and I hope you're not, remember, candor to the tribunal. Transparency may be your friend. Treat others with dignity, you'll be treated with dignity. Be respectful, dress conservatively. If you're in the midst of a grand jury investigation, be compliant. And lastly, what I would say in closing is don't give up the ship. Weather the storm, find that safe harbor. There's one out there.